today to our local practice seminar. Please take a seat. We're going to get started here. Please remember to fill out your blue sheet so you get credit for the seminars you've been attending. Parking. If you parked in the garage, please exit on the hotel side. Go out on the Century Center side. The gate is open, so you don't have to worry about paying. At least so I've been told. Wi-Fi, you've probably heard this before, but if you go into the H Honors, 1981 is the promotional code so that you can connect to Wi-Fi. And as a courtesy to speakers and those around you, please silence your phones and also talk quietly if you're going to have a conversation. So I think we're all really lucky today to have Jennifer Vanderveen with us. She's the founder of Vanderveen Elder and Special Needs Law in Mishawaka. She is locally renowned for her work with Medicaid planning and estate planning. So she's here, she's the past chair of the Indiana State Bar Association. She's the past president of the National Academy of Elder Law Attorneys and the author of Elder Law Advocacy for the Aging, published this fall by Thomson Reuters. So really lucky to have her here today. So I'll give her a warm welcome as she speaks about guardianships.
Thank you. Got a little nervous. She started going off script on me. Sorry. So I wanted to talk a little bit about what is next in guardianships. What's coming down the road? Because we're seeing across the country a shift in how we think about guardianships, how we approach guardianships, and Indiana is really starting to make strides towards becoming more progressive in our guardianship system. So why is everybody talking about this? Oh, which way's forward, which way's back? That's a pointer. Okay, there we go. So, we all heard about poor Brittany. Were her due process rights violated? Probably. Was her money mismanaged? Probably. Did she need help? Yep.
She still does.
And she still does, but one of the things we're going to talk about is there was alternatives than just taking away all of somebody's rights. The poor girl didn't have a right to take out her own IUD. So then there was a movie on Netflix. If you haven't seen it, I highly recommend it. It's called I Care a Lot.
Oh my God, that is great. Oh yes.
It is simultaneously hilarious and terrifying. It's about a professional guardian who basically manages to get guardianship after guardianship after guardianship in front of the same judge, bilk the people of all their money, put them in a home. But yet it gets funny because I don't know how many of you are familiar with the actor Peter Dinklage, but he plays the son of one of her victims, and he gets his revenge. Let's just say that. And then there was a documentary called The Guardians that actually profiled people in the Nevada area who were under guardianship, some of them involuntarily, and talked about their stories. And I watched these and I thought, okay, yeah, Florida, we all understand. I Care a Lot takes place in Florida. It's a mess. Don't live in Florida. Nevada, okay, I hadn't thought about that. But who thought it could happen here? So last fall, there were some congressional hearings about guardianships. And one of the people who testified was this young man, Nick Klaus. And I should tell you all, in the middle of the table are some cards with QR codes, and there's a website on the back. All the materials and all the supplemental stuff I'm going to reference are there. One of the things on that website is his full testimony before Congress, because this happened here in Indiana. Nick was placed under guardianship in 2012 after he was injured in a car accident. His mother and stepfather took guardianship over him. 10 years later, he's got a wife, a child, and a job, but his parents are still his guardian. He said, I can make a doctor's appointment for my daughter, but I can't make one for myself. And his parents were mismanaging things a little bit, and he eventually hooked up with Indiana Disability Rights, who helped him terminate his guardianship. But, don't think this is just a Florida and other crazy states problem. because it happens here. So what is Indiana doing? First of all, there is now a judicial committee working on these issues from the side of the judiciary. They have been working on the statewide registry and accounting systems, which we'll talk about in a minute, as well as developing a guardianship handbook and judicial education on guardianships. I had the privilege a couple of years ago of speaking to the Nebraska appellate judiciary and giving them some education on guardianships. And when I asked how many of the judges in the room had ever actually done a guardianship, none of them had. But yet they were being asked to weigh in on these guardianship decisions. And so, it's making sure that judges, even if they never touch one of these, have a basic understanding of what the guardianship code says, what the requirements are, and how the rules work. Because I'll tell you, we'll get here in a minute, there were rules I didn't know were in there, and I thought I knew pretty much what I was doing in this stuff. So the Indiana State Bar Association Probate Committee has formed a subcommittee whose job is to study the current Indiana Guardianship Code, compare it to the Uniform Guardianship Code, and suggest changes. Somehow I ended up on this committee, and I will tell you we have spent hours and hours and hours combing through the code to come up with some suggestions. We're looking at some possible changes, including how about establishing a standard of proof? Because there isn't one in the code. So is it clear and convincing evidence? Is it preponderance of the evidence? Who knows? We are also looking at amending the list of felony convictions that prevent someone from serving as guardian and allowing discretion for judges to appoint a guardian who may have a felony conviction if they otherwise meet the criteria and are an appropriate choice. Statewide, we're looking at standardizing guardianships across the state. That's why we have the Guardianship Registry, which we should all be familiar with now. And they're starting a new system called My Indiana Accounting, which we'll talk about more in a bit. Finally, the last thing we're going to talk about is less restrictive alternatives. The Indiana Code requires that a petitioner in a guardianship state in the petition what efforts have been made to utilize less restrictive alternatives. And so I'm going to go through some of those less restrictive alternatives and how you can explore those so that if you need a guardianship, you can go before the judge and say, Your Honor, we considered X, Y, and Z, and here's why we determined they were not appropriate. Oops. So the Guardianship Registry, it's a centralized database that collects uniform information from all counties. And it's public record, so I just pulled up a case and gave you a little snapshot of what it shows you. So it shows you that a guardianship was established. Here's my cause number. Here's my incapacitated adult and his year of birth. Here's the type of guardianship, the date it was issued, and who's the guardian. I did not have to log in to see this. So anyone can go on to the Guardianship Registry and see if someone is under guardianship. It's a handy little tool, especially when you've got clients coming in who don't know if their brother or sister was under guardianship because mom and dad have both passed and mom and dad took care of everything. We don't know what they did. Or if you've got a client in front of you who's coming in who's saying my kids are preventing me from doing anything, you can look up and see if they're under guardianship. It is fairly limited in its backward scope. So unless you have filed something in the court to change a guardian or to change from a guardianship of the minor to the adult, it probably isn't going to hit in the system. So we're dealing with, there is a backlog of cases that aren't in the system yet, but hopefully going forward, this will be a really useful tool. Down is forward. Can I just say that? So here's some local rules that are in the St. Joseph County local probate rules that I was reading through as part of my work on this guardianship committee, and I went, oh, because I didn't realize some of these were here. I mean, I'm sure some of you knew these were here and have been doing this all along, but I'm not one of them. So the first is that a report on the condition of the protected person, which you are supposed to file along with every biennial accounting, shall include a report of a physician that guardianship is still necessary and that living arrangements are appropriate. Yeah, I haven't done it. 609.9, your initial accounting is due 30 days after the first anniversary of the appointment of a guardian. 1 year. Then it's biennially thereafter. Who knew? This one really puzzled me because there are more than one county in Indiana that have this restriction, this rule, which is that accountings contain the certification of a bank officer verifying the balances in the accounts. So I grabbed a form, I'm just going to flip forward a little bit here. I grabbed a form from Monroe County. This is one of their forms that says, you know, you give it to them, the guardian signs it, and then the bank is supposed to fill out the name on the account number, the balance, the date, and then a certifying officer is supposed to sign it. You know, just something to keep in mind, because I haven't been doing it. And then the last one is that the guardian shall obtain court approval for all financial transactions other than routine matters. So I'm not sure where that line is. What is not a routine matter? Obviously paying normal bills, you know, normal needs. Is buying a car a routine matter? Is paying tuition to Notre Dame a routine matter? That's a pretty good chunk of change. You know, are those things we should be getting court approval for? So in the world of accountings, I will say I moved up here from Marion County. And in Marion County, they have a probate magistrate named Dan Mullen. And if you file an accounting in Marion County, and you have one copy of a check missing, or you're off by 7 cents, you get a call. Jen, this is Dan. We got a problem. So I come in here. I was a relatively young attorney when I first moved up here, and I go to file my first accounting. Now this is back in the green paper days. And I walk into the probate court with a stack of green paper like this, because I've got a copy of every check from the past 2 years. I've got it all reconciled and tabbed and highlighted. And I handed it to the clerk, and she said, "What is this?" And I said, "Well, it's my accounting." She said, "No, it's not." She grabbed the first 3 pages, my reconciliation, took that, said, "You can just go shred all the rest of this and put it in the file." So things are done differently in different parts of the state. The state is piloting this system called MyINA, which is an online accounting system for guardianships. And it is pretty darn detailed. And you can't just give, here's where we started, here's our expenses, here's where we ended. In fact, when it comes to transactions in this system, these are all the categories of income and how you should categorize your income. Oh, wait, it gets better. Expenses took me 2 screens. Oh no, I switched it on 1 screen. I just squished it. So these are all the expense categories in this system. Who's ever going to want to be a guardian? I will tell you, I have started using Quicken with all my guardians. Most banks will automatically sync with Quicken, so the bank records just flow right in. All we need to do is get the records from the guardian, cross-check everything. Does it all look okay? Okay, save that month, move on. We need to start getting used to, start moving in the direction of being a little more specific in our accountings. And there's a pretty good reason why, because if we're just showing the total expenses and income, we're masking financial mismanagement possibly. If we just say, here's where we started, here's what came in, here's what went out, here's what we got. There's a whole lot that can happen, and here's what went in and here's what came out. When I gave a presentation on accountings in Indianapolis about a month ago, I included a slide that I did not include here because I did not know, who was going to be in the room. But it was from a guardianship here in St. Joseph County. And the professional guardian came to me and said, Jen, we've got a problem, we need to fix this. And I said, well, what? She goes, well, the last accounting was approved, but it was $1.2 million out of balance. And what had happened was, the inventory said $3.8 million. The first accounting starting point was $2.6 million. There was a trust that they included in the inventory but not in the accounting. But if you don't say that somewhere, it sure as heck looks like there's $1.2 million missing. So this is a change that I am in favor of, although I have to say this categories thing kind of scares me. I mean, where do you put, I just look at that and think of some of the expenses that some people that I work with have, and I'm like, where do we put that? Yes?
Do you know off the top of your head, does Elkhart or the other surrounding counties have similar local rules?
Similar local rules, yes. Elkhart has a couple of these. Elkhart is one of the pilot counties for this My INA system. I'm seeing some nodding heads. Anybody used it? Not yet? Okay. But they do have some of the similar local rules. They don't have the bank certification one that I could find. That's the certification. So not everybody needs a guardianship. And let's start to talk a little bit about who needs a guardianship, why they might need a guardianship. So our statute says that a person needs guardianship if they are unable to manage property or self-care, in whole or in part, because of one of these things: insanity, mental illness, mental deficiency, physical illness, infirmity, habitual drunkenness, excessive use of drugs, incarceration, confinement, detention, duress, fraud, undue influence, or developmental disability. Every time I read that list, I sit here and go, ooh. Let's see. Physical illness, well, I was in the hospital for surgery a couple weeks ago, and, habitual, what is habitual drunkenness? Let's talk about duress. We are attorneys. Stress is our way of living. Are we always under duress? Probably. I basically say I could use this standard to declare anybody incapacitated. So when you start looking at what is capacity, you have to start asking a lot of questions. Capacity to do what? Are we talking about, do they have capacity at home? Or do they have capacity when you put them in a car and drive them someplace they've never been? With or without medication? What time of day? Without a proper explanation. So if you're asking someone to make a decision, you just say, make this decision, and you don't explain it to them, do they have capacity to make that decision? With supervision, can someone help them make that decision? I like to say capacity is like butter. There are times, especially if you've got it in the freezer so you want to grate it for pie crust, that it is solid. There is no question in your mind, that is solid butter. If you leave it sit out a little bit, it starts to get a little bit soft. If you have to soften it for cookies, like my husband does, you walk around with it in the back pocket of your jeans for about half an hour. He swears by it, it softens butter perfectly according to him.
Wrapped or unwrapped?
Wrapped. I should clarify. Wrapped sticks of butter, and he doesn't sit down. So, but if you put it in a pan and you let it go too long, it's going to sizzle away completely. But all of these factors, with the exception of it sizzling away completely, could possibly be reversed. So you have to think about capacity not in terms of even black, white, and gray. It's this whole big blob that could go any which way at any which time. So let's talk about situational capacity. Someone could be perfectly capable of making a decision sitting at home in their lazy boy, completely comfortable, versus when you put them in a doctor's office. There is a geropsych institute down in Indy that does a really excellent workup for a geropsych evaluation. Takes all day. I swear to you, at the end of that, I would not have capacity. Because they put these people through the ringer. And they do it because they want to get it done. But it's just, I mean, how many of you had capacity after you took the bar exam? Okay, so those of you who got to fill in little circles don't count. Those of us who did it the real way with pen and paper. It's sad when you realize you've become the old person in the room. So, surrounded by family or in court. So are we all sitting around chatting, making a decision? Or are you in court with someone in robes on a bench staring at you, trying to determine if you have capacity? That can fluctuate whether or not someone can make a decision. We talked about travel, changing surroundings. One of the things they always tell me is that when you have someone with some form of dementia, the last thing you want to do is move them. Because when you change their residence, you will see a change in their level of capacity. Well, how is that different than just, shoving them in the car and taking them to a strange lawyer's office? They get to my office, they're going to think they've been taken, somewhere over the rainbow and be really freaked out. Task-based. So people can have capacity to decide what shoes they want to put on, but maybe not have the capacity to decide whether or not we should launch a nuclear war. Those are two very, very different decisions. And a lot of ways that people easily try to determine capacity is the mini-mental exam. I once had a concussion, and I was actually on an airplane, and they were trying to determine if the plane could take off. So they needed to do a mini-mental on me for some reason. So we go through the first couple things, and I know what's coming, and I just said, I cannot count backwards by sevens when I am my most sober and alert. I just know I can't. So if that's how you're going to determine my capacity, we've got problems. She asked me to name the presidents backwards. By the time I got to Calvin Coolidge, they let the plane take off. Capacity is also transient. It can vary over time. Sundowner syndrome is real. By the end of the day, and it's not just people with dementia. By the end of the day, a lot of people lose capacity. Whether it's fluctuations in blood sugar, or fatigue, or medication wearing off, these are all things that you need to be aware of when you're trying to determine if someone has capacity. One of the things that I always keep on my desk is my well-loved copy of the Assessment of Older Adults with Diminished Capacity, available from the American Bar Association. And it goes through some guidelines about how to assess capacity, what to look out for, what level of capacity are we talking about. So when it comes to capacity, this is a great tool to have in your toolbox. And there should be a link to buy it on my site. I was once in front of a judge who was not here in St. Joe County, and I presented my physician's statement, and I said, Your Honor, Dr. So-and-so has determined that the protected person does not have capacity. He cleared his throat, said, Mrs. Vanderveen, the doctor does not determine capacity. I determine capacity. And he's right. Nevertheless, sort of our best tool to use as evidence is a physician's report, which he then proceeded to admonish me was hearsay, and unless I intended to produce the physician, I needed to get consent to admit the hearsay evidence. When I left THK in April, my rules of evidence were still shrink-wrapped. I had been there for 10 years. I'm looking at this judge like, I have no idea what you're talking about. So the standard physician's form that we've used for years and years and years basically just says, does the person have capacity? Yes, no. Monroe County has developed a more extensive form, which I've started using. I've modified it a little bit. But for example, it asks the doctor to evaluate the person's mental functioning. Are they oriented to person, time, place, situation? Do you have any concerns about their functioning in the following areas? You know, long-term memory, short-term memory, solving problems, breaking down complex tasks. Is there a mental diagnosis? What's the severity and what's the prognosis? So we're giving the court more than just yes, no, so that the judge has something to look at and to go by to say, okay, you know, I'm starting to see where the patterns fall here. When it comes to decision making, this is also on that. Can they make decisions? Yes, with support, no, or I don't know. You know, can they manage a bank account, pay bills, live alone, obtain food, consent to medical treatment? So we're breaking it down. What can this person do? What can't this person do? Now, I will tell you, I have used this form twice so far, not yet in St. Joe County. One doctor just simply put an X at the top and drew a line all the way down, which tells me he really considered it. One, I thought she was taking the route that we used to do on standardized tests where you just start filling in the bubbles sort of in a pattern. But it was more information than I was getting previously. This is where I modified the Monroe County form. Because the Monroe County form originally, this is the following page. It had two boxes with definitions, and it had those on one page and then the charts on another. So I took the definition and put it with the chart so that they're on the same page. But, you know, we're asking the judge or the doctor to say, can we use less restrictive alternatives? Well, if you ask a doctor, do you think less restrictive alternatives are appropriate here? I'll tell you, I've asked 4 of them, personally. And they look at me and they say, what the heck are less restrictive alternatives? I mean, you know, you can't use restraints. Like, okay, no, we're not talking about restraints. So, you know, the Monroe County form gives the code sites, and then it listed the different options. I did specify, I added in, it just said supported decision-making agreement. I added with a healthcare representative or power of attorney. I tried to explain it a little bit more. But again, we're asking the doctor, do you have any idea what we could do here?
Family doctor? I can't, well, no. Is this a family physician or a specific?
It can be anybody with the right letters after their name.
How would a family physician that you go be able to determine in?
You know, I do know, I have met some family physicians that probably would know this about their patients, but I've also had, you know, geriatric neuropsychologists fill this out, and it's really, I mean, if they don't know, they put they don't know. The goal is just to try to get a little more than just a yes/no checkbox, because then we get down to the capacity question, and you know, giving them the definition of capacity is key here, and then totally not with help or partial. I love it when they say partial. It's like, what the heck does that mean? So, we're going to talk about next less restrictive alternatives. And I know y'all thought I was doing boring slides this time. We did the first half a little boring. We're going to have some fun now. So I call these my guardian's avoidance superpowers. And these are all different, less restrictive alternatives that can be tried in lieu of guardianship and that really you are expected to at least consider before asking the court for a guardianship. Number one is limited scope. Guardianship is not all or nothing. The Indiana Code provides a list of powers that can be granted to a guardian. You can pick and choose and ask the court for limited powers. Can the protected person manage some decisions? Are there areas where a guardian is needed to prevent them from making decisions? Well, yes, if that's the case, we want the guardian to have those powers. But in the case of Nick, back at the beginning, I mean, his parents were very strict with him. They gave him an allowance out of his own paycheck and, wouldn't trust him to buy a piece of gum without asking first. So obviously he could make, even if he was incapacitated on some level, he can make some decisions. I've had a lot of clients who, maybe they can't make the decision whether or not to move their IRA all into an annuity or sell their house, but gosh darn it, when the assisted living goes out on a field trip, if they want to have $20 to buy a Starbucks or something, they can handle that. And a full guardianship takes that away from them. Can the parameters of the limitations be clearly stated? If you can't come up with a way to say it concisely, clearly, and identifiably, you need to rethink it. Your limitations shouldn't be wishy-washy. Because if they're wishy-washy, then they are not limitations, they are suggestions. So you want something that you can clearly identify as a guardian do this, guardian not do that. And keep in mind, powers can be modified. The number of guardianship files that come across my desk that haven't been touched in 20 years. And you think, maybe somewhere along the line, A, someone should have filed an accounting, but or B, we need to modify the powers. Maybe they can handle more, maybe they can't. Maybe they can handle less. Superpower number 2 are protective proceedings. So you've got someone who is clearly incapacitated. I had a client who was at Portage Manor. She had a rep payee for her Social Security. She was doing fine at Portage Manor, but she inherited $500,000. And did she need a full guardianship? No, she just needed somebody to be able to step in and say, we're going to take this $500,000 and put it in a trust for your benefit. She didn't need to pay the expenses of having a guardian. And you know what? She could have, the trustee could give her a little allowance every now and then, until she started buying cigarettes for the whole building, and then we had to. I loved her dearly. I was not the trustee of the trust, but she would call me at like 3 in the morning. Mrs. Vanderveen, can I order a pizza? Half the time my husband would answer the phone and say yes. So, when you really only need help with one transaction, a full guardianship isn't the best option necessarily. You can use the Protective Proceedings Code. Trusts. Trusts can be a really good way to avoid a guardianship. And I'm going to tell a story that I have probably told at 8 million CLEs, and so if you've all heard it before, I apologize. But I had a client who was at a nursing home, and his daughter was his power of attorney. She was managing all the bills and everything, and she found out from Dad that he had a friend who was coming and taking him out to lunch. And she thought that was great. Somebody's coming, Dad's getting out,
There's more than lunch going on.
Then she started seeing the bank statements. Turns out he was paying this young lady $10,000 to take him to lunch and tipping the waitress at Bob Evans another $5. And so I'm like, all right, let's puzzle this through. Do we really need a guardianship for this? So we tried a couple of different things. The first thing we tried was, Dad, we're not comfortable with you having the checkbook laying around your room. You know, that's just dangerous. We're going to take the checkbook, we'll leave you a little bit of cash. You know, if you need more money, call. This woman was not stupid, because she just simply took him to Chase Bank and got a cashier's check. Okay, so daughter who is out of state, that's kind of key to this and why we were kind of trying to avoid a guardianship. Daughter's like, all right, what else can we try? I said, well, let's try closing that, or leaving that account open with $500 in it and moving all the money to another account in his name, but that he doesn't know exists. And again, this woman was not stupid, because she took him to Chase, and when they said there's only $500 in the account, he said, where'd my money go? Well, it was wired to KeyBank. So he goes over to KeyBank. Where's my money? Gets the cashier's checks. We talked about trying a trust. And we thought that maybe putting his money into an irrevocable trust that his daughter could use for his benefit. We weren't trying to do Medicaid planning here, but we were just trying to protect the money. You know, would help the situation. Well, in that situation, what happened was the friend got hold of the trust and was like, your daughter's taking away all your money, she's controlling all your money, and he flew off the handle. And so we ended up having to get guardianship because he was in the process of getting ready to file to have the trust revoked and have her power of attorney revoked. And we're like, no. The last thing we need is this woman getting power of attorney. So we did end up finally having to do guardianship. I usually use that as an example for when you might need guardianship even when you have power of attorney. But here, you know, it's where we tried some of these less restrictive alternatives and they just kept finding a way around it. Unfortunately, this woman did not work for the nursing home, or else we could have, you know, really taken her down. But you can't get blood out of a turnip. So a trust is useful, you know, if you've got a protected person who can manage. I mean, if they get SSI of $900 a month, and they can manage that, then, you know, maybe putting everything else in a trust and letting them have their $900 a month is an alternative here. Or if they've got a representative payee in place who manages their Social Security. You know, take the rest of the assets, put them in a trust, have the trustee control the assets, and, you know, everything can go along without the need for a guardian. This doesn't work when you don't need court oversight of spending. So, for example, in Nick's case, if all of Nick's money had been put into a trust with his parents as trustees, he would have been in the same place. There, we really needed the court oversight to say, how is the money being spent? But if it's being put with a corporate trustee, you know, maybe we can get away without a guardianship if we've got this trust in place. A trust also is useful when the only reason that you're looking for a guardianship is undue influence. Maybe putting things into a trust, again, with a neutral third-party corporate trustee will help solve that undue influence problem without jumping through and getting a guardianship. Ooh, wrong way again. Technology. Oh, yeah, Mitch, sorry.
The trust assumes that dad will sign it.
The trust assumes dad will sign it. Not necessarily.
So
You
how do
can-
do that?
Court order, protective proceedings,
Okay.
to put the money into a trust.
Is it a temporary guardianship, or is it some other proceeding?
Temporary guardianship? No, I tend to use the protective proceedings code. Just single time, Your Honor, this is what we need to do, this is why we need to do it, here's your authority to order it. And we get the trust set up. You know,
So what is that person's capacity when they execute the trust in the form of protected?
The protective proceeding is authorizing the power of attorney to execute the trust on their behalf.
Oh, so they don't end up signing?
No, Typically not. They're usually not going to.
They would have had to sign the power of attorney.
Well, they would have had to sign the power of attorney. But that was done when they had capacity.
Right.
I mean, a lot of this assumes that you have structure in place to facilitate these sorts of things. You know, if you've got nothing in place, guardianship may be your only answer. So, technology to avoid guardianship, this is really technology to help people stay independent. Things like auto payment of bills, online banking, so that, you know, the kids or somebody can be looking at the accounts and monitoring the accounts. My favorite is informed delivery through the U.S. Postal Service. I have this for me. I love it because every morning I open up my email and there's a scan of all the mail that's going to land in my mailbox that day. And if you don't tell your husband you have it, you can get home before things. It's also good for aging parents. You know, my mom had this set up on my grandma. She would get an email every day of everything that was landing in grandma's mailbox. And if there was a check coming in or something that looked like a scam that grandma might fall for, you know, she would find a reason to casually go over and on her way in, take the mail in for grandma. Doorbell cameras are handy little things to have because they not only see people going in, they see people going out. It's a way to sort of, you know, keep track of who's coming in and out of the house. Some home security systems will have a door monitor that doesn't necessarily set off the alarm, but you can set it to send you an alert when a door is opened or shut. The door to the basement. Why are you going in the basement? You're not supposed to be in the basement. If you pair this with one of those Alexas where you can just drop in remotely and talk to people, you know, it'll freak them out, but we have one on our liquor cabinet. We left our teenager at home for a week. He knew if he opened that door, Mom and Dad were going to get a text that the door was open. Guess what? He opened the door. I immediately got a text with a picture of the cat toy that had been shoved under the door and the cat sitting next to the door. And he's like, I'm sorry, she wanted that toy. I had to open the door. Whether it was true or not, I fell for it. I choose to believe my child. But you can also use technology in your practice to help enhance the capacity of your clients. And what I mean by enhancing the capacity is giving them the tools they need to understand the decision that has to be made. So whether you are increasing the readability of your documents, I have a 55-inch flat screen in my conference room that my husband swears I just bought to watch F1 races on, but I do actually use it in client meetings to blow the document up so they can see very clearly what we're talking about. You can also use technology to check the readability of your content. There's a number of websites out there, Readable, WordTune. Hemingway is my favorite because it goes through and shows you where all your problem sentences are. But it will tell you if your document is readable and at what grade level, and make suggestions for how you can make your communications to your clients more understandable. I ran a special needs trust through Hemingway, and we found 4 words that weren't highlighted for some reason. So, you know, we're not going to solve all the world's problems with this thing, but I run client letters through it every now and then, my handouts that I give clients, just to check and make sure that I am speaking in a language that people understand. Video meetings are great for people who have marginal capacity because you can do that at their time, in their setting, where they're comfortable. You just have to take precautions to make sure that they're not being subjected to undue influence. I did have a colleague in California who actually had the case of the family standing behind the laptop with grandma's dog. People are weird. So my last superpower is supported decision making. I could do a whole day on supported decision making. But this is something that is relatively new. It is not a substitute for a power of attorney or an advance directive. It's used in conjunction with it. And it is basically an agreement between the protected person and their supporters as to who makes what decision. Now, it is a legally binding contract between those people, but it does not carry much weight, if you take it to Chase Bank, are they going to say, no, it has to be agreed on by the parties. And this is good for situations where capacity might be changing, it might be evolving. Where I really love to use it is with 18 and 19-year-olds with developmental disabilities who are becoming adults and who don't necessarily want to be slapped under a guardianship. So can we come up with one of these supported decision-making agreements where you agree, here's what mom and dad have to weigh in on, here's the decisions mom and dad have to make, and it takes some reminding and some coaching, but I've been able to, so far, knock on wood, avoid putting some of these kids under guardianship because they realize that once they are under guardianship, they have very, very few rights. And they don't want that. They want the ability to have some freedom, to be able to vote, which is unclear here in Indiana, whether someone under guardianship can vote. Some states it's very clear they can't. So it's a way to set boundaries. It can be changed frequently. It's also a way to get the family to talk about where they think the deficiencies are. And what has surprised me the most is that in most of these situations, when I sit down with the family, the child thinks they can make fewer decisions than the parents do. And it is so empowering to watch some of these kids get this supported decision-making agreement and, be able to say, hey, here's what I can do. Especially if they're out there, they've got a job, maybe they're starting to live independently. Giving them some agency really goes a long way into giving them some dignity. So that's probably the most aggressive of the less restrictive alternatives. Like I said, I could do a whole 2 hours on it. I do have some materials up here on it, and there's a link, where did I put that? In my materials to the ABA has the practical tool for lawyers. And it is steps in supported decision making. It walks you through basically what the basic tenets of a supported decision making agreement look like, what sorts of things to consider, and how to set one up for your clients. The other thing I want to show, I know I'm keeping you from lunch, real quick. This is a book that just came out from the ABA called The Fundamentals of Guardianship. They've had it for a while. This is the second edition. This is for the guardian. This is something that, giving to the client, the guardian, highlighting it, marking it up. These are some things that you need to be aware of, some of your duties. Are you checking on this? Are you checking on that? It literally gives them checklists that when they go into a supported environment, they should be looking at the cleanliness of the clothing, the hair, are the nails trimmed? Do they have access to hygiene supplies? More than just walk in, look around, does everything look okay? It sort of gives them the guidebook of what to look for. If it's too much for your client, I find an X-Acto knife takes this apart quite nicely, and you just pull out the parts you need. It's actually kind of therapeutic sometimes. But with that, do I have time for questions? I've lost track of my time.
You still have,
Oh, I still have 10 minutes? I thought,
you have slightly more than 10 minutes.
Well, I'm going to throw it open for questions, and if not, I'm going to keep talking about supported decision making. Question, yes?
You talked about doctors, right, and not understanding less restrictive alternatives. Have you had situations where supported decision-making, in particular, of a way to craft it where the protected person, especially young adults, are not confidently making their own medical decisions, and in a way where whoever's supporting them is allowed in the room to talk to the doctors, giving some kind of authority there without them insisting upon the guardianship?
The question, just for recording and for everyone else in the room, is have I come up with a way to craft that supported decision-making agreement so that doctors allow the supporters to be in the room and to help make that decision or make that decision for them? Yes. the first thing is I never do it without a healthcare power of attorney or advance directive also in place. And if you name someone different as your supporter than the person you named in your power of attorney, we've got a problem. So it's generally the same person. So we've got that power of attorney in place. I also have them sign a separate HIPAA release to allow mom or dad in the room. It's typically mom or dad is doing this. And most of the doctors that I've encountered so far have been doctors who are dealing with a lot of developmentally disabled kids. So when we give them the supported decision-making agreement and they look at it, you know, they get it because they're dealing with this a lot. If we were in a hospital situation, emergency situation, I would have to rely on that power of attorney. And I don't know that they would insist on, I haven't had anyone insist on guardianship if I've had a power of attorney in place. Unless the kid is saying something different. You know, if you've got the patient saying no and the power of attorney saying yes, well, obviously then we've got a conflict, which I haven't run into yet, knock on wood. But for the most part, these agreements have been pretty well received by, I've only really worked with 2 doctors with them, but they've really embraced them and have even contributed to my list of questions with, you might want to add in here who makes decisions about X, Y, and Z. I hadn't thought, who makes decisions about birth control? And I had one of the doctors come back to me and say, you might want to add that to your agreement. Because we're having that discussion and, you know, who's going to make that decision? So far, knock on wood, I haven't needed to go get a guardianship. But I mean, I can see the circumstance where that would happen. Any other questions? All right, I'm going to talk a little more about supported decision-making agreements then. Let me grab something from over here real quick. Because I do have up on the table here some of the handouts I use for clients on what is a supported decision-making agreement and how to use a supported decision-making agreement. And one of the key things is making sure everyone is on the same page. So when I start a supported decision-making agreement, I send a little online survey to mom, dad, and the kid. And I tell them I want them each to fill it out separately. And it's about how they feel about this agreement and this process, and do they think this is going to work, so that I can see where I might not have buy-in. The first people I had do it, mom submitted one, and the child submitted one, and mom said, well, this is for dad and me. I said, no, that's not the way this works. Because I'll bet you, there are places where dad has different opinions. So it's making sure it doesn't work unless you have buy-in from everybody. And when you start thinking about what decisions to put in this agreement, I have been working on a supposedly simpler way to come up with these agreements, and so far I'm at 85 different decisions that could be included in the agreement. And it's everything from, can the person pick an apartment, to can the person own a gun? And, some of them, it's easy to weed out. They go through and they say, well, this doesn't apply, and that doesn't apply, and that doesn't apply. Well, okay. But I've run into situations where it might. If the child has a history of going out hunting with dad, where does the gun stay? Can he have his gun in his apartment? Or does it need to be locked in dad's gun safe? Who makes that decision? How much money can the person handle on their own? So it really does, it's a really, really deep dive into the capacity of someone. And again, I'm going to stress, you should never do a supported decision-making agreement without either a power of attorney and healthcare directives or with a limited guardianship in place. Because the supported decision-making agreement alone does not give authority. It simply delineates where the agreement is on who's going to make what decision. I was a naysayer on these until I had a client come in and absolutely insist that we were going to do one. And I said, all right, well then we're doing this together. And, you know, she has a law degree, although she doesn't practice. And so literally we co-drafted this first one because I was like, how in the heck does this thing work? They're 3 years in and it's working beautifully.
Why can't you just put it in so you're saying you get a POA, and
Right.
the document really limits the POA.
The document doesn't limit the POA because I still want that POA to have full authority.
Well, I understand that's the authority by the statute for the decision maker, the supporter, whatever you want to call it. And I understand that that's the main thrust of it. But instead of going through a separate document, why can't you delineate all these in the POA itself?
Because if I delineate all these in the POA itself, and I get to a point where my client clearly doesn't have capacity, let's say he's in a car accident, in a coma, and I've got this power of attorney that says, you know, no, you can't make decisions about X, Y, and Z, I've got a problem because then I've limited that authority. And so I want that backstop, just like we would do a power of attorney for anybody else. You want that backstop. And then this is just another layer added onto it. Plus, if I put all this stuff in a power of attorney and they take it to a bank, can you imagine? I mean,
It just seems like this is a memorandum of understanding. I mean, what happens when there's a disagreement of one of those 85 points, and where do you go? I mean, unless you incorporate some kind of mediation or something between the family. I mean, it seems like a lot of time and work and effort when all that has to happen is, I don't agree with that anymore.
so it is a memorandum of understanding. And everybody signs off on it. I have had a couple of disagreements regarding it.
How do you handle the disagreements?
How do we handle the disagreements? Right now, the couple that I've had have been handled through informal mediation.
Okay.
But, you know, the document is drafted with the intention that it is a binding contract.
Well, what's the enforceability of this contract?
The enforceability of the contract, I mean, it's being able to say that, you know, we agreed that you would do this and you didn't. I know it's weak, I know, and I believe me, I get this, but in the circumstances that we're talking about, it can allow the parents to feel more secure, giving the child more agency. I've actually done it for one older adult, where, you know, the kids were uncomfortable, and so we came up with this family agreement, and
Well, I understand it could be therapeutic. I don't see it as legally binding, but it could have therapeutic value.
yeah, I mean, I haven't tested it yet. I know, and I don't know off the top of my head, the Indiana code provisions regarding supported decision-making enforceability, I probably should have looked those up before I came in here. I mean, I know in some states it is enforceable by statute, but really it is.
Do we have a statute on point?
We have a statute on point.
On this agreement?
Yes.
Oh, I didn't know. Sorry.
Yep, Indiana does have a statute on point. I don't, like I said, I don't know what the provisions are as far as enforceability, but there is a statute on supported decision-making agreements. It is, oops, wrong way. Okay, I just completely shut it down. Where did I have it? I had it on one of these. 29351A.
11.
Thank you.
Thanks.
Don't you also think that the parties themselves would feel like they had accomplished something and they had specifically delineated and specified who does what. And that does a lot for both the parents in your examples, and that the child still has some power.
Exactly.
Still has some individual abilities. And so that is the therapeutic side, but I think that people will be, and I think, more likely to talk, if they get into a dispute, well, wait a minute, we said that you could do this and that I could do that.
And I actually developed flip cards for one of the young gentlemen, where he could look real quick, can I do this? Can I not do this? Can I do this? Can I not do this? But my time is now officially up. We have now officially wasted 10 minutes. So I will send you off to lunch.